Okay, so what's the order of plus sections in California legislation? By the way, what is a plus section? Basically, there are one or more sections at the end of a bill that provide specific provisions that are uncodified provisions. So when you consider California bills, these uncodified sections that are at the end of the bill are not placed into statute, meaning they're not codified, they don't appear in the codes, which contain all of the state's codified statutes in the 29 codes. These sections at the end of the bill are called plus sections because they're in addition to the regular provisions of the bill. Generally, there's an order of these plus sections. However, because the California Legislative Council office keeps their drafting manual confidential, we don't know for certain what is the precise order, but based upon a review of existing bills the last few years, I've come up with the following best guess at the proper order of plus sections. Double jointing, this section is used to address when one bill would chapter out the language of another bill that amends the same code section and that might get enacted before because the later enacted bill prevails. Followed by contingent enactment, this section is used to make a bill contingent upon either the enactment of another bill or perhaps a budget appropriation or some other contingency. Severability, this plus section is used to protect other provisions of a bill if one or more provisions are found to be invalid or unconstitutional or are voided by a court. A no appropriation provision. This is a section for where an appropriation would otherwise be made under the Welfare and Institutions Code, but the legislation says that no appropriation pursuant to a specified Welfare and Institutions Code is actually required. The appropriation, this section is used to appropriate monies from either the general fund or a special fund with specified form language that includes the amount from which fund to what entity and for what purpose. A section 2230 or section 2229 waiver. These are sections used when bills either exempt property for the sales and use tax or from property tax, and the legislature does not want to reimburse local governments for those lost taxes. They use form language. Maybe next could be section 41 findings, which in some tax statutes in the Revenue and Taxation Code are actually codified, but they can also be codified. And so this section, this plus section, would be used to comply with Revenue and Taxation Code section 41 to make certain legislative findings and declarations, specify goals and objectives of a tax expenditure program, and specify the performance metrics that will be used to evaluate this new or expanded TEP, again, tax expenditure program, and whether or not it's effective. Public funds disclosure, this section would be used to specify that a retroactive payment or a retroactive tax law change does not constitute a gift of public funds, which would otherwise violate Section 6 of Article 16 of the California Constitution. Next up in that order could be the reimbursement mandate. This section is generally disclaiming any reimbursement to local agencies when a bill, for example, would create a new crime or otherwise impose a state mandated local program. Next up, the 2011 realignment legislation. This section is used when local agencies are required to implement new programs or expanded levels of service beyond those that were imposed as part of the 2011 realignment enactment. Next section could be when you have to further the purposes of a ballot measure. So this plus section would be used when a bill amends a statutory initiative that's been adopted by the voters, and a legislative amendment is permitted by that ballot measure. The public right of access disclaimer is one we find. This section is used when a bill limits the public's right of access to local or state government meetings or public writings, and we need a disclosure there. Next could be a special statute. This section is used when a general statute will not suffice, and therefore a special statute is required instead. And we have a finding and declaration as to why a special statute is necessary despite section 16 of Article 4. The next one, I think, would be the urgency clause, usually near the very end. And of course, this section is used when an urgency clause is required. The Constitution in Article 4 requires a statement as to the facts constituting the urgency. And so that has to be in a plus section. And I think one of the last plus sections normally in the order would be for a bill that's related to the budget bill. And this section is used for budget trailer bills and utilizes language that the bill would provide for an appropriation that's related to the budget bill. And therefore, under section 12, section 12 of Article 4, it is a bill related to the budget, and it's actually mentioned by number in the budget bill and therefore takes effect immediately. So again, I think that's the best compilation I could come up with the order of plus sections in California bills.